I know our next panel is also going to weigh in some more on the next steps that we think may or may not happen. But I do want to turn to Josh now because when DACA rolled out, we didn't see any lawsuits right away that challenged DACA. In fact, we didn't see lawsuits around the DACA or related programs until 2014 when the president moved to open an expanded version of DACA that would have qualified more people, and also that DAPA, Deferred Action for Parents of Americans program. So, Josh, I wanted to hear your perspective on what are the problems legally with the DACA or the DAPA program?
Sure. Thank you so much to Cornell for having me. It's always a pleasure to speak to people in New York. I'm from Staten Island, so it's always good to come home. I'm in a weird spot. I think that DACA is a good policy. I think that DAPA is a good policy. I don't think the president had the authority to enact it. And I don't think it was implemented in a lawful manner. One of the other panelists mentioned that there was a huge debate within the Obama administration. Did the president have this power? And President Obama said time and again he didn't. Ultimately, he changed his mind after the the DREAM Act bill failed in Congress. So I want to sketch at a high level the legal problems with DACA. The first involves statutory law. Did Congress give the president, and specifically the Secretary of Homeland Security, the power to implement DACA? Now, there are a couple statutes that say that the Secretary can set priorities within his enforcement of the laws, but there's actually no statute that says you can give deferred action. There's no statute that says that. It's understood to be permissible as an executive practice that's never been defined, so I'll give you that much. Is there a statute saying that you can give lawful presence? Now, there's some regulations that reflect lawful presence, but there's no statute that says here are the criteria in which you can give it. So the entire basis of DACA was in this very shaky foundation. And in 2012, or actually 2014, the Obama administration released a memorandum justifying the DAPA program, but also discussed DACA. And they said that we understand that this is on a shaky ground, but we are okay with it because it fits within past practice of what's been done before. Not that Congress expressly approved it, but that was consistent with what previous presidents have done before. In 2014, I wrote a couple articles concerning this where I think those arguments were ultimately incorrect, and let me explain a very basic reason why. Deferred action is an old practice that goes back decades. But the relevant framework that we have today only goes back to the 1990s. We had this huge immigration reform in the 90s, which repealed a lot of the old statutes. So we have only about a decade or 15 years to go on. And it's never been the case that deferred action was granted in the same manner it would for DACA. So I'll give you an example. In 2005, Hurricane Katrina hit New Orleans, right? Let's say you were a foreign student studying at Tulane University. You had a student visa, but your school shut down, so you lost your visa. President George W. Bush said, we will give you deferred action till next semester, so you get re-enrolled at another college. It would make little sense to deport someone who can go enroll at another university the following semester. Deferred action was historically used as a bridge where someone had status and lost it, or there was status waiting for them at the end of the bridge where they're certainly going to have it. DACA is something else entirely. There was no gold at the end of the rainbow for the DACA recipients. Their only option was to renew it after 2 years or 3 years, however it was. DACA was, I think, an administrative action designed to bridge the gap till another Congress is elected, and that hasn't happened yet. But we still have these people who are stuck on the status for 6 years, 8 years, or perhaps even longer. So that's the statutory issue. There was no statutory framework. The other aspect is one of administrative law. One of the panelists mentioned that they only had 60 days to stand it up, and if they put it through the administrative process, it would have taken forever. Exactly. Congress passed the Administrative Procedure Act to ensure that agency actions are properly vetted through what's called the notice and comment period, and that courts can consider them before they go into effect. By just announcing this from the Rose Garden in a beautiful ceremony, you bypass this entire regulatory process. I think this was a mistake. In fact, we're now seeing a court say that President Trump can't rescind DACA through the exact same process that was announced was by memorandum. The last legal question is one about the Constitution. And there's a fairly obscure provision of the Constitution which no one cared about much until 2016, which is the Take Care Clause. The Constitution says the president has a duty to take care that the laws are faithfully executed. The origin of this provision comes from the English Bill of Rights, where the King of England would suspend the law. He just would not enforce the law. And I think this is an instance where President Obama and his administration said, we're not going to enforce immigration laws. We're going to not only defer the deportation, but grant lawful presence, which includes work authorization and other benefits, to a large class of individuals that Congress could not get around to protecting. Congress tried to protect the Dreamers, and they couldn't. And only after Congress failed, they turned to executive action. And I think this is a prima facie case of bad faith enforcement of the law. I think it is unconstitutional. Now that's DACA. I think DAPA is actually more defensible because the people who are getting the benefits have a relation to a U.S. person, right? They have a U.S. citizen child. The Dreamers have no connection to a U.S. person, so they're even farther attenuated from those that Congress sought to protect. So to summarize, I think that DACA and DAPA are good policies. They should be enacted by Congress, but the agency didn't have the authority to enact it. They didn't go through the proper administrative process. And also I think it runs afoul of the President's duty to take care that the laws are faithfully executed. Thank you.
Thank you. Thank you for that summary and that insight. I want to make sure that we leave a few minutes at the end for Q&A. So before I ask Josh another follow-up question, I wanted to see if Esther or Tyler, you wanted to respond.
What I would, yes, thank you. What I would do instead of taking, since we are short in time, directing people to a couple of areas that they could go to read to listen to the other side of the other view with respect to the legality of DACA and specifically the decision by Judge William Alsup from January 2018 that goes into extensive detail, point-by-point detail with respect to the legality of DACA. There's also excellent testimony from Steve Legomsky, Professor Steve Legomsky, before the House of Representatives in February 2013, again, that goes point by point, rebutting each of the points that Josh just made with respect to the legality of DACA, and finally to the OLC opinion that came from the Department of Justice.
Thank you. So Esther pointed us to quite a few different resources to seeing the other legal side from what Josh had explained. And obviously reasonable minds can and do differ on this issue. And in fact, that has come to a head, or is coming to a head now, in that in September 2017, the Trump administration announced that they would be rescinding the DACA program, winding down that program and phasing out anyone who had DACA. And that is really when some more litigation around DACA itself began, with states challenging the rescission of DACA. And then we see, in addition, states challenging DACA itself almost as a response to the DACA rescission litigation. So, Josh, you described this to me as basically two tracks of litigation. And so before we take Q&A, I'd like to hear, if you can, a summary of kind of what's going on right now and when is the Supreme Court going to give us an answer?
Well, Jeff Flake just announced he's a yes. So I think that there you go, breaking news. So let's see, one fan in the room. We have two tracks of DACA litigation. So after the presidential election, Texas, I'm from Texas, threatened to sue the Trump administration unless they rescinded DACA. They said, we will sue unless you rescind DACA. A couple months later, the Attorney General said, okay, we are rescinding DACA, and they released a memorandum providing some reasons why the policy was to be rescinded. Not to be had. Judge Alsup, who I think it's in San Francisco,
yes.
not Virginia, announced that it was unconstitutional for President Trump to rescind DACA because he hates brown people. I'm grossly summarizing, but the upshot is he says that President Trump is an animist towards people from around the world. He hates Mexican immigrants. He said so himself. Therefore, it violates the Fifth Amendment to wind down the policy. I don't think this ruling is going to hold up. I think there's a very low chance that holds up. The second track is that states have tried to say that the DACA rescission memo is unlawful. So we have one challenge in saying Texas that the DACA policy itself is unconstitutional, and the second challenge is the effort to rescind DACA is unlawful. I think the way the Supreme Court works to have this is that, you know what, President Trump can wind down the policy. We don't have to address whether the policy itself is legal because the president can wind it down, and that's ultimately what's going to happen. And that leaves a tough position, right? Because again, I think the DACA recipients are entitled to protections, and I think they ought to be by statute, but not by the Constitution. If, in fact, the Supreme Court says that DACA can be wound down in maybe 19 or 20, give or take, whenever it happens, that's going to put a huge amount of pressure on Congress to take some sort of action, because they will not allow people to renew their DACA paperwork at that point. I think that'll be a huge crisis, which I think is unfortunate, but I do think will be the correct application of the law.
Thank you. I'd love to hear some questions from the audience. Q&A? Any questions for our panelists? Great, please. Oh, she's got the mic for you. Thank you. It's being recorded.
Lenny Benson, New York Law School. I understand why USCIS was chosen to process, because they're the agency with the bodies. But did you seriously consider, like, the opponents who challenged DACA to say, if this is an exercise of discretion, why isn't the discretion being adjudicated by a unit within Immigration Customs Enforcement? So I'm just wondering, like, why was it USCIS was the arbiter? And if I could put the answer in your mouth, it's because the inherited authority to grant deferred action or discretion comes from the district director, which is the chain of command up through USCIS. Sorry if that was too in the weeds for people, but that's how immigration law is.
No, I would agree with everything you said. It was a program that was created to direct discretion, and the discretion comes from the very top, and then the adjudicators that were doing this were instructed, you're supposed to look at these cases on a case-by-case basis and decide whether there should be a favorable or unfavorable exercise of discretion. It was a process that was put in place to look at the exercise of discretion.
Does anyone else have a question?
Can I ask one?
Sure.
It's for Josh. So your theory on the legality of DACA is that the government does not have the ability, or at least the use of deferred action was, you cited the example of Hurricane Katrina, international student who was in lawful status who would have fallen out of status by not being in school. So let's look at the specific example of someone such as Jalissa Arce, who entered lawfully in the United States, was unlawful. There's still an opportunity to be lawful again in the future. Under your theory, DACA would be appropriate in that circumstance, wouldn't it?
What visa did she enter under?
She entered under a tourist visa, so she was in lawful status.
So
through no fault of her own, because she was a minor, fell out of status. So that deferred action would have been an appropriate one. So
if I could ask, and what would be here possibly for status in the future?
She married. She obtained permanent residence through marriage. So there was an opportunity in the future for her to legalize based on the policies at that point. So under your theory, if it served to bridge the gap, it served to bridge the gap there. So what happens with that populace?
So the bridge example was actually one developed by OLC, and I can address this in turn. There were 5 instances in which deferred action was granted, one of which was a Katrina, another one was with T and U visas, another with spouses of military, right? This was someone who had status waiting at the exact opposite side. A tourist visa, that is a temporary permission to enter, was not considered the type of beginning status that would help you bridge the gap. In other words, Congress didn't give someone a tourist visa with the idea that perhaps they may change status later.
But they legally allow it.
They legally entered, but for a short duration with understanding that they would leave.
Student enters for short duration,
But a
also
student
with the intent to return.
But they would have had it immediately afterwards, a chance for renewing it for another visa as well.
Tourist visa, I leave the country, I come back in legally, I have the chance to
So
come back
let me just
again.
make this point, taking a step back here, right? Deferred action exists in a fairly narrow sphere. The Obama administration never went so far to argue that someone who enters with a tourist visa and then might get married at some point in the future could possibly re-enter. There are 2 and 10-year bars, for example. They have to get married outside the United States and re-enter. There are a lot of things that have to happen before that status can be entered. But this was not only a change of status. This was an ongoing granting of lawful presence and work authorization. And we have to define where it is within the statutory framework. And there's really no basis within it to expand to someone who merely enters with a tourist visa and might hypothetically get married at 20 years in the future. That's a bridge too far to permit lawful presence.
Who's the judge of that it's a bridge too far?
So the bridge too far is what's known as the delegation doctrine. It's a principle of law that says unless the president has a power with some intelligible principle, he can't exercise it. And the further you get from the statutory framework, the less stable that claim is. I would even perhaps go so far to say that the basis of deferred action is very tenuous. It doesn't exist by statute. So you have to subscribe to it very narrowly. And the fact that you thought you needed a statute to do it, I think is evidence that the president didn't already have that power to begin with.
So how do you cross-apply this to the travel ban then?
I have to. Actually, I think the travel ban would violate the non-delegation doctrine. Let me take a step back and explain. Congress enacted a statute that says the president can deny entry to those he deems detrimental to American interests for as long as he wants. That is a broad delegation of power. There's no statute saying that you can grant deferred action. But I think for the same principle, because Congress didn't give enough guidance to the president on implementing the travel ban, it's problematic. However, there's a big but. The president has an inherent power, according to doctrine, to exclude aliens from entering the United States. The courts recognize this. The president has no inherent power under the Constitution of granting sort of license or naturalization. So they're very different statutory frameworks.
But he wasn't granting license or naturalization because there was...
He was granting lawful presence.
He was granting lawful status, not
Lawful,
presence.
no, the statute, the regulations say lawful presence, and that triggered the application of work benefits and other benefits. This was a granting of lawful presence. It was not naturalization, but it was lawful presence.
I'd like to let Gabby jump in. She's got a question too.
It was just, I'm that example. So I came with the tourist visa. How I was able to go to college was with the international student visa, and I applied for it while I was here. I don't know how, and a lot of attorneys always try to figure that out, but I had an international student visa, and then I applied for DACA and got DACA. So, and there was I've been documented through that period of time, but I serve as your case to prove, and last year I actually obtained my green card. So I am the case that you guys are talking about. I went through it.
The bridge worked for you.
Thank you.
Before we turn back to the panelists, is there any final question from the audience?
Yeah.
Thank you, Lenny. So with that, we will conclude this panel. We have lunch in the reception room, and we encourage you to pick up your lunch over across the hall, and please come back because we will be hearing from our keynote lunch speaker, Representative Carlos Curbelo. Thank you.
Thank you so much, sir.
Thank you.